Good morning and welcome to Melanie's Minutes, where we discuss a workers' compensation issue by the beach because workers' compensation can sometimes be a beach. My name is Melanie Diegelman. I'm an attorney here at the law office in today, and today I'm going to talk about the issue of MMI, specifically whether or not a claimant has reached MMI. And this really comes up when we get an IME and our IME says, yes, the claimant has reached MMI and provides a severity or permanency opinion regarding either an SLU or a classification or a permanent impairment to the spine. And we then present to a hearing and we request the direction for the claimant to produce medical evidence of permanency, and their doctor has not provided or they have provided an opinion of C4.3, but claims that the claimant is not at MMI. Essentially, a general rule is a claimant will reach MMI 2 years after the injury or 2 years after the surgery or a year after surgery. It really depends. It's a case-by-case type of basis, but the claimant will reach MMI, and there should be special circumstances why they have not reached MMI within that 2-year period. And essentially, a lot of doctors will say, well, he might need surgery, but that is not strong enough to prevent a finding of MMI. The surgery, if it were to prevent MMI, then it would have to actually be requested if needed, approved if needed, and actually scheduled. There's just a simple claim that he might need surgery someday down the road is not sufficient for not finding the claimant at MMI. So if it has been, 2 or more years since the injury, again, depending on the specifics of the injury, there really should be no reason why the claimant's not at MMI, and we would like to move these claims toward permanency, get them closed if we can. So therefore, it's really, if awards are ongoing, then we recommend securing an IME and permanency, and then requesting the claimant, a direction to the claimant to produce the same. Also, though, it depends again on the claim. For example, if it's an SLU claim and there are no ongoing awards, then we really don't recommend getting an IME on that right away because it's really the claimant's burden to provide permanency. So depending on the factors of the file, but there really should just, for a PPD claim, it should be no more than 2 years unless there's something in the file that's glaring that shows that he should not have reached MMI by that point. So if you have an ongoing claim that's older and it's not yet been classified, then we would be more than willing and happy to help you with that file. If you have any questions, please feel free to reach out, and we will see you next time. Thank you.